So after looking at how little actually happens in Strasbourg, the next obvious question is, okay, but what about here? Aren't our own courts constantly tied up in human rights claims? Because if you listen to some politicians, you'd think every other case is someone shouting, Article 8, and demanding their cat has visitation rights. So I went digging again, and the picture that emerged was, well, not the dramatic circus I'd expected. First thing to get straight, the Human Rights Act and the ECHR aren't the same thing. This trips almost everyone up, so it helps to have a clean mental picture. The ECHR equals the international treaty we helped write after World War II. The Human Rights Act, HRA, equals a UK law passed in 1998 that lets you use those rights in UK courts. You can think of the HRA as the local outlet of the ECHR. It turns a distant process into a domestic one. And that's where most cases are. Not in Strasbourg, in UK courts, using UK law. So let's look at what actually happens with all that. Second thing, human rights barely feature in the vast majority of UK cases. This was the one that surprised me most. The UK legal system handles around 4 million cases a year across everything: criminal, civil, family, tribunals, immigration, the works. Out of all of that, only around 1 to 2% even mention the Human Rights Act at all. That's mention, not win, not succeed, just someone raised it in passing. So straight away, the idea that the courts are drowning in HRA claims doesn't hold up. It's more like a trickle than a flood. Third thing, most HRA-related cases aren't even about challenging the government. This really changes how you see the whole issue. More than 80% of HRA mentions pop up in things like family court cases about children, criminal trials about fair procedures, homelessness decisions, mental health tribunals, and domestic violence protection orders. In other words, everyday issues that affect, well, pretty normal people. Not terrorists, not foreign criminals, not dramatic news stories. Just the day-to-day business of making sure decisions are fair, lawful, and not cutting corners. So what about challenges to central government? That's where the headlines tend to focus. Real number, roughly 350 to 600 judicial reviews per year mention the Human Rights Act. And of those, most don't go anywhere, many settle before judgment, some succeed, a lot don't. When you boil it down, only about 35 to 120 successful challenges happen each year. That's across all government departments. For a country of 67 million people, that's barely one successful rights-related challenge per week. Not exactly the legal apocalypse. And these successful cases, they're usually about basic good governance. When the government does get something overturned on human rights grounds, it's almost always due to unlawful detention, not considering children properly, poor reasoning, decisions rushed or done on autopilot, procedural mistakes, agencies overreaching or using powers incorrectly. It's far less ideological battle, and far more, you forgot step 4 on the checklist. These cases are the judicial equivalent of a teacher saying, you had the right idea, but you skipped a page. Go back and sort it. Not some dramatic challenge to democracy. Does all this cost money? Yes, but the scale matters. People often imagine huge, spiraling legal costs. The reality is quite mundane. A simple judicial review for the government might cost £15,000 to £40,000. More complex ones can be £70,000 to £120,000. Rare mega cases go higher. Add it all up and you get maybe £20 to £30 million a year across the entire government. Sounds like a lot to you and me. But against a Home Office budget of over 20 billion, it's a rounding error. And it's worth remembering, most of these costs would still exist even if the Human Rights Act vanished, because the same issues would be litigated under common law fairness, administrative law, immigration law, or public law challenges. The labels would change, the cases wouldn't. So is there a flood of human rights claims? If you zoom out, the whole system looks like this: 4 million cases a year. 10,000 mention the HRA. 500 actually try to challenge central government. 50 succeed. And those 50 are usually correcting avoidable mistakes. The idea that the courts are bursting at the seams with opportunistic human rights claims is mostly a political story that doesn't match the day-to-day numbers. What you actually have is a small safety valve that occasionally says, "Mate, that decision needs a rethink." Which is sort of what the whole thing was meant for anyway.